Good evening, friends, and a big and a warm welcome to you to this very special edition of WAF Gurus Live, episode 13. 13, without it being symbolic in any way. So, friends, this is the edition where we talk about the legal disputes in the COVID era. We all know that the courts are closed. Only urgent matters are allowed. Video conferencing is the medium of the courts. We don't know when the courts will open. I was talking to a friend of mine in the High Court. He said probably it might not be even before September. Then people might have some regular issues, common issues. Where do they go? What kind of advice you can give to them? So what we did, we collected around 10, 11 top points that we, received from that World Order Forum members around the world, and we made a laundry list. So let's have a look at them and let's get started on this beautiful journey of solving people's legal disputes through simple solutions and practical tips. So I just share my screen. Right. So this is our web page of our website. Okay. So this is the topic which gets us there: legal dispute resolution in the COVID era. WAF Gurus Live episode 13. And these are the legal gurus today in the house. We have, of course, Mr. Gopal Jain. He's a designated senior advocate of the Supreme Court of India, having quarter of a century experience. We have Mr. Manish, Lamba. He's the senior vice president at DLF, the largest real estate developer in the country. Then we have Ms. Shweta Bharti. She's a senior partner at Hammurabi, one of the top law firms of India. Then we have Mr. Vineet Agrawal. He's a leading in-house counsel at an established car maker. Then we have Ms. Neeti Sachdeva. She's the Secretary General of the Mumbai Center for International Arbitration. So a lot of ADR inputs we might need in this session as the courts are closed. Of course, we have Mr. Vikram Sobti. He's a partner at Chandhiok and Mahajan and an expert in the dispute resolution practice. And of course, it's me, Anuj Guglani from World Order Forum. So, and these are our beautiful annual partners. We take annual partners and they are there with us through the year, and they're very special to us because they help us pay our bills. So, of course, amongst our gold partners, we have Gallup's Motors. Gallup's, friends, is one of the leading retail automotive chains in the country. They represent several automotive brands and they are known for their class-leading customer service. Then we have Motor Uncle. Motor Uncle is a group company and it is a website for the confused car customer and the hassle car service customer. And then our OEM partner, that is the original equipment manufacturer partner, is Volkswagen, the #1 car maker all over the world, known for their cars built and quality. Then we have Amplus Solar. Friends, Amplus Solar is on a mission to transform automotive power, the way automotive gets power to solar. So they want to convert all these dealerships and warehouses and factories, and they want them to be powered by solar, making automotive truly green. Then we have Shell. Friends, Shell, as we all know, is world's #1 lubes company, and they are the partner at World Order Forum. Then K2B, they are a leading training and enterprise learning company of India. And of course, Jubilant, another very, very famous and established retail automotive group. They represent several brands in cars across the country, and as part of the Jubilant group, the Hindustan Times group. Amongst our media partners, we have Autotech Review, the leading auto tech journal, and Patriot, a newspaper with a fine lineage, which was started by a revered freedom fighter, Srimati Aruna Asaf Ali ji, 6 decades back. So these are our annual partners. Quickly coming to the laundry list of points that we had received from our members around the world. So friends, this is supposedly our agenda. If you want to, talk, extend, diversify these issues, most welcome. So stuff like, financial obligations. Moment the lockdown hit us, everything came to a grinding halt, factories closed, economy, took a massive dip. So whatever were the financial obligations, they also took a dip. So a lot of financial obligation issues are there. Then unpaid rent issues. People stopped paying rent. They wanted to save money for the rainy day. The rains were already on. It was pouring actually. Then check bounce cases were, all over the place. And, because a lot of digital was happening, a lot of work from home, so a lot of cyber frauds, phishing, as it is, India is the second most cyber attacked country all over the world. #1 is US, we are #2. And for 3 months, for last year, we were the most cyber attacked country. So whenever we are hit by a cyber attack or a cyber fraud, what do we do? What should be the 1, 2, 3 steps and, go to person or entity? Then general fraud or, cheating cases. Then lot of extreme matters relating to foreign jurisdiction, because we are in the middle of a pandemic. The entire world is affected. So when there are issues across foreign soil, how do we deal with it? Then contractual obligations which were unmet, vendor client issues. A lot of feedbacks came on this. Then a lot of big companies declared force majeure. Ironically, one side they were doing CSR, they were donating to the PM CARES fund, and on the other side they were declaring force majeure to their vendors and suppliers. So how do you resist one? Then a non-paying employer. This again, came from a lot of quarters that hey, I've stopped getting my salary. Or hey, my salary is delayed. Or hey, I've been asked to get a cut. Or hey, I've been asked to leave, got a 2 months notice. So what is the process? Retrenchment, bonus, going to a labor commission, manager cadre level people saying, I'm being retrenched or salary is reduced. So stuff like that. Sudden loss of job, as I mentioned. So these are the points that we have received. So without further ado, I'll stop sharing my screen and let's straight away get into the conversation. Let's start with our designated senior advocate Sahab, Mr. Gopal Jain. So, sir, you know what's going on. You know how people, are going through these, challenging times. You've seen the points that we have received. What are your quick thoughts on them?
Yeah, thank you, Anuj. I think, like we all know, these are unprecedented and unexceptional circumstances with one common theme: the entire world being affected by this at the same time. Very rarely do you have a phenomena which affects everyone across the globe at the same time. And that is what has resulted in number of legal, we're today concerned only with legal issues. So all these challenges which you've enumerated and others come primarily from the fact that there's complete large-scale disruption and dislocation of human life and businesses. So who looks at contracts and who looks at law when life itself is at threat? So we have to first, before realize that no law or no contract could have ever imagined a situation like this and consequences. And therefore, no interpretation, no precedent will ever fit this situation. Even if you look at what people have talked about, the Spanish epidemic, etc., that was confined to certain areas. So that's why we have this complete chaos and the curiosity that people have, the anxiety that people have, and the questions which have. And therefore, I take the point which you made at the beginning, that this is really time for new thinking, practical thinking, an approach of resolution, because even forums to which one turns to are also affected by the side effect of COVID. And therefore, I borrow the word from the Prime Minister, it's Atmanirbhar time. We have to find resolutions and solutions within ourselves and using platforms of mediation, conciliation, etc., because everyone has a challenge of liquidity. So if you look at many of the issues that you mentioned, the common theme which will run through that is liquidity. So if businesses are stopped, they're not earning. If they're not earning, you don't want to honor your obligations or you don't want to pay. And yet both sides need a balance, because somebody who's committed to working in a place for several years has no other source of income. And equally, businesses say, for example, hospitality and other ways, there's complete closure, which have not opened, that unless we earn from the business, how do we pay? So these are, like I said, novel and unusual situation, because nobody would have ever thought there'd be an airport, but the airport won't function. There'd be a hotel, but the hotel would be a hospital. So traditional revenue streams itself have been affected. So I call it a challenge or a war on liquidity, and that results in some of the issues which you have raised. Next is another common theme. The moment something like this happens, we pick up new words, and this force majeure was this new kid on the block. So people started sending force majeure notices without knowing what it means. Let me give you two examples. I think it was in February 2020 or March, in that period, the government of India issued a notification saying that because of a natural calamity, they declared a force majeure. Now, pandemic is not a natural calamity, but so be it. It got stamped. Step one. Step two, the expression force majeure is really found in contractual relationship between parties, and broadly, it's really giving more time to perform your obligation. But people found that as a good shield not to pay. So you're actually using force majeure not to pay. I'll give you a third very interesting example from the power sector. Simplifies the situation. So the Ministry of Home Affairs, as you know, issues notifications under the Disaster Management Act, and they say, look, round the clock power supply is required. So power supply is an essential service. Please continue round the clock. The Ministry of Power issues a notification telling the distribution licensees who get the power that, look here, you may pay 50% or not pay for a period of 3 to 6 months. And to generate power, you have a supplier, and the supplier says, listen, unless you pay me, I'm not going to give you fuel. So the generator turns around and says, I am supposed to work 24/7, but my payment you have taken away. And the same distribution utility which says, okay, please generate and give me supply, also issues a force majeure notice. So he's asking performance when it comes to receiving supply, but he's saying there's force majeure when it comes to payment. So it's absolute chaos which has resulted as a result of this. So we should use this exchange to try and see if we can bring some clarity and consistency to this. And lastly, I always say that these are times not to break relationships. So people have knee-jerk reaction, and that's expected because we've all been through the same syndrome. But people need these relationships over a period of time. So today, like I said, it looks nice. You say, I put force majeure, I don't have to cut out a check. May not be legally tenable or sustainable, but you're also injuring that relationship. And migrant labor is such a great example. Today, the construction industry does not have adequate workforce or skilled workforce. So their productivity is less, including with social distancing protocols. And likewise, the manufacturing sector. So you realize how important your workforce and labor force is, but they were not given the kind of treatment they were given earlier. So you have to keep the relationship intact. And that's where it comes to balancing. And the entire Indian legal system is founded on the premise of equity, justice, practicality, which is all about balancing. So when the RBI says to the banks, give a moratorium, all that it means is, all right, I'm not saying that you guys will not get your money, but give period of a borrower some cooling time. So these are ways of balancing, of molding, of fine-tuning the commercial relationships and finding and restoring that equilibrium, which is why we require a new approach, as you started at the top of the show. So we should forget the past and said, let's start with solutions, creative solutions, and fair solutions. So the moment somebody says, I'm not going to pay you, that's an absolute one-sided thing. If you say, I'll give you a 30% haircut and in good times we'll come back, people can live with it. So this is where I think we require the expressions fair, open, transparent, equity-minded, justice-minded have greater significance today than they've been used in the past, where it was just a word which was fancy to be used, but that's the need of the hour.
Great. That's fantastic, Mr. Jain. So basically, giving a haircut in such a way that the person looks forward to it. Huh? All right. So this was about, being thrusted or pushed force majeures down your throat when their meaning was also not clear in entirety. And also, as Mr. Jain mentioned, that force majeures might not be legally tenable, but why break the relationship, at the first go? So taking that point and, coming to Mr. Lamba, who's a senior VP at DLF. So Mr. Lamba, even your, business associates say in your organization, because real estate and, these malls and a lot of these entities and bodies are really hit because people stop paying rents and, the income stopped coming because there were no customers in the retail. So when these people come to you or they ask for, time or a moratorium or, what are the strategies and practices which really hold good in the market? And if force majeure is pushed down the throat, what are the possible ways to handle it?
Okay. Firstly, the views that I am expressing are that of mine and not that of my company. But I'll give you I'll give you a 360-degree view of what's happening, and I will only take cue from what Gopal has said. First of all, force majeure is a word which has always been there. It has been subject to various interpretations. Pandemics and epidemics have not been new to the human history. They are as old as the human history itself. You can find traces of the first pandemics 5,000 years ago, and probably in 540 BC, you will find subsequently many pandemics which has happened. And the last one which we remember is the Spanish flu. Spanish flu was the only time when we saw that insofar as the Indian census in India, the population came down, A, because of the Spanish flu, and B, because of the World War One, which had at that time just ended. So therefore, these concepts were always
in your audio. Your audio is not clear.
okay. Just give me a second.
It's having that radio, disturbance. The radio chatter. You have gone mute.
Am I audible now?
Yeah, it's. Can you please speak again?
Okay, am I audible now?
Much better, much better. Please continue.
Okay, so what has happened is, what I was trying to say is that insofar as this pandemic is concerned, pandemic and epidemic are not new to the human civilization. They have been always there for thousands of years. It can be some of the first pandemics can be actually traced back to 5,000 years. And if I come down by the history, the last which we remember is that of the Spanish flu. The Spanish flu, which happened during the World War I time, and that was the first time that the Indian population, for the first time between one census to another census, declined. But today, what is the difference? Insofar as these flus are concerned and these pandemics are concerned, they are carried by human from one. It was carried from ships. When they first went to Europe, from Europe to US, they were carried to Spain. Spanish flu did not start in Spain, but yes, it did not participate in the war, and their newspapers were free at that point of time. They published a lot of articles, and that's how we know. But what has happened insofar as the force majeure is concerned? So insofar as the real estate is concerned, it says that it's very easy to shoot out a notice at the first instance, let the adjudication take place. Today, let me send a notice and say that it is a force majeure situation, not pay my rental for a period of 3 months. By the time the courts will decide, it will be 2 years, and in between, if possible, we will get into some kind of a settlement. So if that is the approach, and that is without knowing, without understanding, many of the people sent us notices for the purposes of force majeure. Force majeure is very easy to allege, very difficult to prove, and very difficult to get relief. The manner in which it is said that it is not for the purposes of suspension of obligations. It provides only in a situation when a situation of that nature arises, you are excused from the contract. So there could be a situation where you can break the contract and say that I'm not going to perform. But in case of a lease, you cannot say that for the inter agonum period, I'm not going to pay. As I say that Neeti and her organization, MCIA, would be running insofar as their arbitration center is concerned. If somebody was to say that now nobody is going to there and she's not going to pay, the builder is further not going to pay to the bank. So we will have bad banks, as a result of which what is going to happen is the banks are going to fail. If the banks were to fail, then the whole economy is going to fail. So therefore, even in Supreme Court, the question which was there, that insofar as the moratorium is concerned, kindly do not put interest on interest. If those kind of logics are taken, the entire economy will come to a standstill. And if you look at typically insofar as the real estate contracts are concerned, they would have a typical clause which would provide you an excuse. Parameteria provisions are there in the Transfer of Property Act, which would say that if the property is destroyed or damaged, until such time it is restored, you will get that kind of a relief. People think it is fine. Pandemic may or may not be a force majeure. Assuming that it is a force majeure situation, then also you will have to look into your specific contract whether or not you are going to get that relief. Now that understanding and that gap of that understanding, because of which a lot of confusion has been created. Thankfully, there is a judgment of the Delhi High Court which explains that if the parties have not in their contractual bargain agreed that in the happening of a named event which is force majeure, and if that event was to happen, then the rents would be suspended. So that has brought some clarity, and insofar as the energy watchdog case which is concerned, and which is very of the Supreme Court, that defines the contours and the parameters in which we have to work. That aside, that is not important whether or not you are covered in the force majeure. As Gopal has again said, that we all need to live and survive. We will only be able to live and survive that if we were to honor our contractual commitments and or rewrite, renegotiate, redraw our contracts as and when and as and where they are required. Unless as a society we understand these dynamics and tailor make our contract, change according to the situation, take the holistic view into considerations and then come out with business solutions. If we were to look at only legalistically, as you have said, that the courts are today only hearing those matters which are absolutely important or necessary, or where the heavens are going to fall. That's the kind of a criteria. But before the heaven falls and the man survives, there is a long life to go. And therefore, in that interregnum period, we will have to address and understand the new normal and its new realities, adjust ourselves according to the new normal, or the it will be, as it said, AD and BC and AD. So it will be before Corona and after Corona. That's how life is going to be. And when a lot of things are going to change. You used to have conferences in hotels and where people used to meet, and today you have completely shifted over to this. Similarly, I think Neeti will also have our arbitrations completely and absolutely on. If we can have these conferences, we can certainly have arbitrations also. And if we can have arbitrations, we can have court proceedings also. The courts must realize that this is not a holiday time.
Absolutely.
Not a recoupment time. It is for them to, they should not shut their doors. They must create that 8 hours of judicial system for everybody, and we must all move towards technology. And the courts cannot be shut for long, and their doors open only when they are knocked for emergency situations is not something which is acceptable. They will have to conduct these hearings on Zooms of the world and on the Skypes of the world and maybe WhatsApps of the world. And therefore, the delivery system has to completely change and move in that direction.
Great. Fantastic. That's really well said, Mr. Lamba. In fact, taking a cue from what you mentioned about going about digital, in the video which we were playing just before we began the program, we took a target that through the entire year, we will engage 1 million professionals in automotive and mobility through the entire year. And you would not believe, in just a span of 3.5 months, we're about to cross 1 million. Just of this series that we started on 28th of March. That's the strength, that's the power of digital. And that's across 125 countries. One quick question I have for you, Mr. Lamba, because you are working with the biggest real estate player in the country. So, when the courts are only taking urgent matters, say if there are some rent issues, not just say of your company or big organizations, but even say a normal person who might just have 1 or 2 properties or just 1 property, senior citizens, they're not getting the rent and they're requesting, and the other person has the capability, but they're not paying intentionally. So in such matters, can they go to the court? Would the courts take it as an emergency matter? If not, what is the possible resolution?
See, basically, as we have seen in the case of one of the High Court, in one of the cases in which a relief has been granted, in most of the cases, you will get almost no relief. There is no way, even if it would not have been a pandemic, it would have taken 18 months to 1 year or maybe 3 years. And even if it is an arbitration and a fast track arbitration, it would not take less than 6 months. And then you have 34 and things of that nature. There is no quick fix relief which is provided for. And the answer to this situation would have been in the last but one budget. They had come out with a new Tenancy Act. And that Tenancy Act provided that if you do not pay within 3 months and things of that nature, or you will have to pay 4 times that kind of a rent, and all that what you need to show to the court is that the person has not paid rent and he will be thrown out. But for 2 years, insofar as that draft tenancy bill is concerned, is lying in the cold storage and nothing has been done. So it is high time to take out those bills which are lying, or those draft bills which are there, for the government at least to implement them in the states in which they are in power. So nothing has happened for the last 2 years, and now we have a pandemic, this kind of a situation. So it is now the time the government is taking out many bills and many reforms are going on. Insofar as today is concerned, this is one reform. They must take it up on an urgent basis, and if they do so, there would be some kind of a succor and relief for all. So it is a message that insofar as that the Model Tenancy Act should be brought into force as of yesterday.
Okay, got it, Mr. Lamba. Okay, so we switch gears and now we come to Miss Shweta Bharti, who's a senior partner at one of the leading law firms of our country. So, Miss Bharti, what are your thoughts? I shared those 10 points right at the beginning. Please take a pick. You can select the points which are your favorite points, which probably you're working on, and it's all yours.
Thank you so much, Anuj, for giving me this opportunity, and I really appreciate the points of discussion that you have raised. Some of the points that Mr. Gopal Jain mentioned and Mr. Manish Lamba mentioned, I would want to briefly touch upon. So far as the issue of getting a relief for the landlord is concerned or the tenant is concerned, we are representing a few organizations in different courts. And interestingly, believe me not, the courts at places like Haldwani, Bulandshahr, Chhindwara. So these are the places that I have been representing the client, and the courts are e-functioning, and they have been giving relief to the landlords as well as to the tenants both ways, understanding the present situation and also directing in cases where the tenant is being thrown out by the landlord, understanding that there is a legal process to follow because the landlord had started just locking the doors of the tenant's house and all those situations. So they actually took the kind of direction that was given by the court is not to take illegal action or not to take an action in contravention of the law or the agreement. So there have been interferences by the court in these small places where it was not expected of the courts and tribunals to have a visual hearing. They have started doing that, and they have started interfering, and they have started passing orders. So that was a welcome change for people like us who are able to sit at my residence at Delhi and are able to represent my client at a place, at a court at Chhindwara or at a court at Haldwani. So that is the kind of penetration we are seeing of the courts. And so far as the interference of the courts is concerned, the courts are understanding, appreciating, and passing decisions. So I would say that that is something which is very positive as a change. Now look at the issue that you have raised with respect to force majeure. What is a force majeure? I mean, we have been hearing this term so much, and for the last 3 months, I think we have done and dusted with interpreting this term force majeure as such. So if you look at it, it is not really an Indian term. It is a French term. It means in equivalence to a vis majeure, or in Latin it means superior force. So if you look at the Black's Law Dictionary, the definition of force majeure is that it is an event or an effect that can neither be anticipated nor can be controlled. So that is how it has been provided for. A lot of people are confusing this word force majeure with the doctrine of frustration under the Contract Act. And that is also one of the issues when we are dealing with the kind of advices that we are giving to clients. This is one thing which is coming repeatedly as a concern for the clients. So they are getting intermixed between what is a force majeure situation, what is a frustration of contract. But these are two completely different terms. So the concept of force majeure is neither defined nor has it been dealt with under the Indian statutes. It is only under the Indian contracts that we have started providing for it. If you look at section 32 of the Indian Contract Act, we provide for dealing with the contingent contracts. Similarly, if we look at from the contractual perspective, what kind of a force majeure clause provides for temporary reprieve? It provides to a party from performing its obligations under a contract upon occurrence of a force majeure. So that is under the contract. So if we have to look at the COVID situation and the outbreak of COVID and then the lockdown which has happened, and what exactly happened thereafter. So whether it was a force majeure, if it is a frustration of contract, if you look at the landlord tenant agreements, most of them may not really have a force majeure clause, as Manish ji mentioned. So can we then take a plea that it is a frustration of contract under section 56? So we have to understand exactly where we are and understand what are the ingredients when we are talking about force majeure, what are the ingredients of a force majeure clause, and what are the ingredients under the section 56 of the Contract Act. And then we have to understand whether the situations in which the doctrine of frustration is to be applied. There you can seek an excuse of the performance. But then certain grounds for frustration are established. So what are the grounds in which you can seek a frustration of contract? You can ask for when there is a likelihood of destruction of subject matter. Manish ji also mentioned about it. If there is a death or incapacity for personal service, or if there is an intervention by a legislative or executive authority, or there is an intervention of war, or there is a change of circumstances which are of a particular state of things. So if you compare between section 32 of the Contract Act, which talks about the contingent contracts, and section 56 of the Contract Act, which talks about the frustration of contracts, it is in itself a matter of construction, and it complies impliedly or expressly a term which can be used to discharge on a happening of a certain circumstance. So the question of dissolution of the contract according to its term fails to be determined under 32, but not under section 56 of the Indian Contract Act. So we have to understand very clearly on these two words what their meanings are, what their interpretations are, and how it is to be applied. The second scenario that we are seeing is, the application of these clauses under the employment agreements. The employment agreements usually do not have a force majeure clause at all. So that is where, the applicability of it becomes a challenge. The third kind of a scenario where we are seeing this clause being applied very commonly now is in situations like vendor disputes. That is also where this clause is being interpreted, and the clause has such a wide connotation that sometimes it may or may not really be in these clear terms, and whether this pandemic situation would fall under that force majeure clause or not, because it talks about certain situations or occurrence of a certain situation. So if we look at the vendor contracts, it may or may not really be applicable. So these are kind of scenarios where there is a lot of interpretation which is required, and that is where probably the lawyers' role come into play, where people like us, all of our panelists who specialize in these issues, are able to give advice on whether we are going to apply force majeure in a certain situation, or we have to go for frustration of contract in a certain situation, because both of them have their own consequences as well. So that is something which also is required to be understood by the client. So we will talk about the rest of the issues a little later, but I think these are two issues where there is a lot of confusion. And even though we have series of judgments on the interpretation of it, right from the Supreme Court interfering in the Mugni Ram Bangur's case, and till today, there are multiple judgments on this issue. But still, I mean, there is a certain amount of vagueness which has been, played around with before the honorable courts.
Surely. In fact, Ms. Bharti, that was a fantastic comparative analysis you just brought across, between force majeure and the section 32 and 56. And you very clearly, proven that how force majeure is being used and abused left, right, and center. And there is a huge confusion, not just amongst, when there is confusion in the legal fraternity, what to say about the common man. So with those thoughts, we come to Mr. Vineet Agrawal, who is the leading in-house counsel at a leading global car maker. So, Mr. Agrawal, what are the sort of challenges that you are seeing, for the legal fraternity post-COVID, post-lockdown, and what do you think are the basics that a common man should be empowered with, the basic legal aspects for them to survive this COVID battle?
First of all, thank you so much, Anuj, and thank you every other participant. First, we understand why this COVID has come, because every person is speaking COVID, COVID, COVID. It's like a dance we are playing, like COVID. Importantly, it is a nature who has challenged us. We are exploited the nature, and now nature is taking his rebel back from us. And if you see the history, after 100 years or 125 years, it always comes as a bounce back to us. So it keeps us reminding us we have to give something back to our nature. So that is the first preface I would like to add. Now come to the legal perspective. If we have seen, the Supreme Court has already taken into the this situation, and on 15th March or from 24th March, they have extended the period of limitation. For all under the power of Constitution, they extended the limitation period for all the cases or all nature of the cases, whether across the country. And the court further extended this on its 6th May 2020 order to Arbitration and Conciliation Act, as well as to the negotiable instrument. But very important caveat the Supreme Court has put, that it cannot go endlessly. After it will take 15 days. So suppose tomorrow lockdown opens, So you get only 15 days time. So I think for the lawyers or in-house counsel, the important point for us is to get prepared. And we should be ready, suppose the court open. And it is very worth to mention here, as of now, as per my understanding, it is not the COVID who has created the force majeure. To my knowledge, it is not the COVID. Why? Because it is the government order who had created a lockdown in the country, and the government has acted under the direction of National Disaster Management Authority to create the lockdown, and each state has got the directional power from the central government, and each state government is giving their own orders. So meaning thereby, the important problem here is the central government is giving separate orders and the state governments have their own orders. So that's the dichotomy is coming, and that's why a lot of confusion is getting. Now to answer to your question, which I really appreciate and very like that Gopal ji said, we have to keep balance in our approach. Why we have to balance in approach? If I speak from the corporate side, it is very easy to give an advice. Please file the case, go fight 1 year, 2 years. But you have to be balanced from the economical perspective. Suppose I today decide to file a case. Is it a cost involved? Answer is yes. Is it time involved? Time value for money? Yes. So you have to make a balance over what you are getting and what you are expected to get after 1 or 2 years. So what is your present value of that money? That's one part of it. And to answer to the common man of things, so first of all, we should all have to understand this COVID is not going to today. It is not going tomorrow. It is living with us. I think, and I should be wrong in that, it should not go within 6 months. And I pray that it should go early. But if you see, our life has been changed totally. It is not something same life we will continue. So in that case, our expectation from the corporates or our expectations from other parties has to be reasonable and equitable. And if we have a balance in approach, definitely in the litigation, you cannot think that you can win each and everything. You are also going to lose something. So make some sacrifices, 10 or 20% or 30% of your outstanding, and you get some money today. I think that's very important. So manage your liquidity. So that's a point from my side.
Vineet, something on the foreign jurisdiction, if you can throw some light. A lot of our members were asking, says a lot of people export some stuff, they import some, materials. So when there are issues with companies on foreign soil, foreign jurisdiction, of course, Neeti will surely throw light on the ADR part of it. What can be the options when you have some dispute with a foreign company in a foreign land?
Again, with the foreign jurisdiction, the important issue here is each country have their own jurisdictions or way of interpreting this COVID. For example, if we have seen that a lot of countries even have not declared lockdowns. They have not yet declared some epidemic position or the force majeure condition in the country. So if you are a party who is exporting the product, so first point is you should secure yourself that your money is secured. It should not be the case you supply the product and you not get the money. Second point, suppose you are supplying to the other party, check thoroughly credential of the party, whether he is financially able to pay or not to pay. Because third, if you are going to start a litigation out of India, definitely it is a very costly affair. And yes, you can start the audio-visual mechanism to resolve your disputes. But I feel going 1 year or 2 years, it will be very, very difficult and it will be very, very costly affair. So rather than doing a hasty decisions or like pushing yourself to get a liquidity of your company, it's always better to be a more cautious approach to export the product. Second, from import side, if I say, again, the government of India is coming a lot of protectionist measures to protect the economy. Yes, there is a challenge and you have to pursue with the ministry. If they possible, they can give your leeways. I think that can be the best solution. Yes.
Slowly, Vineet. So because the courts are closed, there are limited options we have, and as also Vineet mentioned that instead of taking a hasty decision, give it a 1 year, 2 year view so that it gets solved amicably. So that coming from a leading in-house counsel, I think it means a lot. So shifting case. So now, friends, let's talk about ADR. We have the Secretary General of Mumbai Center for International Arbitration in the house, Ms. Neeti Sachdeva. So Neeti, you've been patiently listening to all of us. The courts are closed. The spotlight is on you and your center. So what are your thoughts?
Thank you, Anuj. Firstly, thank you for having me here and to all the panelists for setting the stage. Anuj, I agree with you that this is like everybody's talking about it. And I'm not going to be any noble than what noble can I be, that this is unprecedented situations, right? Dispute resolution, and unfortunately lawyers and lawyer institutions survive when there's an economic turndown, which is a sorry state of affairs, but that's the kind of a profession that we are in. Now, the problem arises is this, that when we are in a situation of this sort, and I totally that it is not only about resolving your disputes, it is also about maintaining your relationships. A lot of disputes we have seen can get settled through ADR mechanism if only parties were to come on the table and were able to hear each other rather than having a very adversarial approach of pointing each other's faults. And I would say more so in today's situation, that is what we require. Now, as an arbitral institution, of course, our doors are always open to parties to get their disputes resolved. And we have no difficulty in doing that. But we have always maintained a very cautious approach. Cautious approach in the sense that unlike going to a court, which is your right, coming to an arbitration center or going for an arbitration dispute is something which is parties' autonomy. Both the parties to a dispute have to expressly agree that yes, they want to come to arbitration for resolving the dispute, which can be the first difficult situation itself if you do not have an arbitration clause in the contract itself. So already when the parties are in a disputing situation, they do not want to agree to each other. For them to agree that yes, we will refer to A, B or C institution, or we're going to go for an ad hoc arbitration, can become a challenge. But if that challenge is then overcome and parties do feel that they want to put their good money behind the bad money and get their issues resolved, then arbitration, I think, in today's time is a viable opportunity. Also viable opportunity because unlike courts, and especially now that we're seeing you can go to the courts only for urgent matters, there will be, of course, a backlog as well. You might need some urgent, immediate relief and may want to pursue your claims later in the day. Arbitration can come out to be quite quick and I would say cheaper as well in certain circumstances. In fact, recently we had a matter which was referred to us which had nothing to do with MCIA. Though I have to say it was a government body involved at one side. The clause did not provide for an arbitration with MCIA. And the private contractor, it was a construction dispute, private contractor went to the court and they said that our contract has been terminated. We have been asked to remove the machinery from the site and the government has floated a new tender. And if the tender was to go by and a new party was to be appointed, then even if I have a relief a year down the line, I would be left with no remedy. And the court, what they did is that they, with the consent of both the parties, the court proposed it and both the parties agreed. And they referred the matter to MCIA to appoint the arbitrator to have an interim hearing. And I'm very happy to report that we were able to appoint the arbitrators within 48 hours and have your interim hearing done in 72 hours. And an order was given within 15 days of your matter being, referred to the MCIA. And it's not only for MCIA, I can speak it for other institutions as well, that parties are usually very, very, when they repose faith in an institution, these kind of disputes can get resolved particularly quickly there. But like I said, the underlying principle has to be that the parties will have to agree to come to an arbitration. I would take this opportunity to also debunk one of the myths, which parties feel that going to an arbitration is actually adding on to a layer of cost, which may not be true entirely, always. Of course, for your low value claims, it may not be advisable to go to institutions all the time. You may be spending a lot of money. But in my humble experience that I've had over the years, we've seen that if you have a good arbitral tribunal and the parties have come on the table, even though it's not mediation, it's arbitration, a lot of time in the middle of the arbitration, parties realize that we could very well settle this dispute and go forward with doing the business for the relationship to continue. So that's probably my two thoughts on what lies in today and for future time to come.
So that's great, Mr. Sachdeva. And a lot of people also say, please don't kill the messenger for that, that the probability of corruption or biases setting in is much higher in arbitration or ADR vis-a-vis a formal court, because in a court, the judges, at least that fear is there, in arbitration, because there's no that kind of fear. In fact, I had overheard one very established industrialist once mention carelessly to me that he had gifted a Q7 to one of the arbitrators to get a decision in his favor, and he took it, without any fear, because he was now retired, so he didn't fear nothing. So such things, people keep hearing. So what do you have to say to people when they say that the corruption can seep in much faster or easily? What is the response to that?
Thank you so much for that question, because it just helps me to talk about and champion the course I've been doing for last 15 years probably, which is asking the parties that kindly move from ad hoc to institutional arbitration, whichever institution. I do not deny what you've said, and probably what your industrialist friend mentioned as well. Because it's a private adjudication process, you do see sometimes these problems arising, maybe more often than not. But that is when I say that an institution can play a very major role, because the institution's role is to keep those checks and balances. At the end of the day, it's an institution's reputation as well, which is attached to the whole arbitration process. So just for the audience, for the sake of telling them very quickly how this whole process works. So let's say, Anuj, God forbid, you had a dispute with one of our panelists. Let's take it from Mr. Manish Lamba.
I didn't pay rent to him on time.
And if you would...
I thought we were very good friends, huh?
It's a friendly fight. It's a friendly fight.
So my rent wave. Thank you so much.
No. Gopal, then the allegation would be that arbitration is a friendly fight. Don't do that. Go on.
If you were to refer the dispute to institution like an MCIA, then what does the institution do? If it's a sole arbitrator, that is one arbitrator to be appointed, then either the both parties can agree on one name. So let's say agree to Mr. Gopal Jain. Institution still does its checks and balances before we appoint. And what are these checks and balances? Which is, I say, as an institution, we have an institutional memory. We have our own processes by which we can take information about different people, gather those information, and then say that, yes, he has availability of time. He's a person of impeccable integrity, and there'll be no harm in appointing him as an arbitrator. If it's 3-member tribunal, we always have, let's say, Shweta is appointed by Manish sir, and you are appointing Vineet. Then institution will appoint the 3rd arbitrator, which is to get in Gopal. There is the whole fees of the arbitrator, and the process is then run under the aegis of the institution itself. So that's where it is a wall, a barrier to make sure that all those corruption charges, all those issues don't creep in. Now, Anuj, I must say as a disclaimer, I can't say that institution is a panacea for all your problems. We can't even say that for judiciary. But yes, whatever best one can do, I would say, is that the party should try and move from ad hoc to institution to get the same balance, whether you're a claimant, whether you're a respondent, whether you have deep pockets or whether you don't have deep pockets.
Fair enough. That's a very valid point made by Mr. Sachdeva.
Anuj, can I just come in for a minute, because this is a very important point that Neeti has made. Is it all right to come in for a minute?
Sure, sir.
So I think the message, as you said, for all users, and that's really important, that we have to lean to some forum or some institution, because there has to be some measure of trust and therefore credibility in the platform, because we can't be left without any remedy or any forum. And I think just to touch on the point that Neeti was making, that when the process of award comes from an institution, they have their own self-corrective mechanism, because it's the integrity of the institution. So you will say ICC award, MCIA award. You don't say the name of X or Y. Whereas when it's an individual or an ad hoc, it's more known by the name of that person. And many institutional forums also have a court. So they would do a rigorous fact check and scrutiny. And the moment arbitrators are under an institutional umbrella, for the reasons that she said, that there is an institutional memory, they would like to be in the good books of the institution to get more arbitrations. So everything acts as a checks and balances or a self-corrective measure to ensure that the integrity and the impartiality of the award is there. And two, and I say again this with all humility, that all institutions offer a much wider bouquet and choice of experts. So today the need of the hour is to find a subject matter expert to resolve a dispute, because you will get accuracy, predictability, and likely predict outcome closer to the contract than having a lay person and the other category, which I don't want to name, but we all know. So go-to has to also change now. It must be people who know. So if we have an issue in a pandemic, you will not go to a GP, you will go to a specialist of a particular kind. So one other advantage of institutional arbitrations is, in terms of the choice of people and panel, is specialization. And I really suggest to users that in the new era that we are going to see, please go to specialists so it's handled with care, handled effectively and quickly.
Great. Well said, Mr. Jain. So, Mr. Deva, so here Mr. Jain is working your case very well, I guess. Huh? Okay, so we shift gears and we now go to one of the leading lawyers for dispute resolution in the country, and who's been waiting very patiently for his turn to come. And we shall give him some extra time because he has waited so patiently. So friends, the wait is over for Mr. Vikram Sobti, who is the partner for dispute resolution at Chandhiok and Mahajan. So Mr. Sobti, you there?
Thank you, Anuj. Thank you for this opportunity and very kind words from you, used by you to describe me. Coming after all these distinguished panelists have spoken about various topics, and I'm the only one who is the barrier or the obstacle between the Q&A sessions to start. So I would not take too much time here. I would like to be crisp. I wish to state only on points where the distinguished panelists have not spoken about or not touched about, because probably I'll pick a topic which is more procedural in nature. So since this pandemic has come, obviously everyone has talked about the substantive rights of the parties at either side of the spectrum. But what about when you want to exercise these rights? When you want to go to courts and want to exercise because probably the advice has not worked, or when one of the party is not budging or not coming to a settlement. So let's talk about how the courts have functioned since this pandemic has hit us. Right from the beginning, when you want to file something, the filing side of the litigation has really suffered. Even though courts have tried their best, Vineet sir rightly said that the Supreme Court was very prompt in passing order, extending the limitation in all general as well as special laws. And they also were very prompt to give clarifications on such limitation orders as late as in May. In fact, on 10th of July, they also said that you can service the notices of courts by WhatsApp, and that would suffice. So yes, Supreme Court is with times. They are open to adaptation. They're open to new means and modes. However, are we actually functionally ready? Because I can tell you from personal examples or personal experiences, for example, filings like NCLT, Shweta ma'am would know much better. She has a good practice there in the insolvency basis. But my experience has been that even though they've allowed for online filing, because obviously you want less and less interaction there, ultimately when they do tell you to go there and again file a physical copy, the whole purpose and intent is lost. So those kind of obstacles need to be removed. There needs to be more rational thinking of how we need to make things faster, how do we need to make things more effective. As far as urgency of the matters go, those also are given very wide meaning sometimes, or I fail to understand the urgency behind FIR lodged against Arnab Goswami, requiring the attention of the Supreme Court, and where migrant workers' plight took so much of time to reach the ears of the Almighties. So be that as it may, obviously the Supreme Court needs to take those steps, because as again the panelists mentioned, this thing, as we hope, might go away soon. But hoping is one thing. As we litigators always say, you prepare for the worst, but you hope for the best. So we should prepare for these eventualities to last. So we should obviously give more credence, give more thought, make more efforts towards digitization to make courts prepared. I understand when Shweta ma'am also talked about access to justice. Of course, it's brilliant for our great Mr. Jain here sitting, and he can argue a matter. I can take him to any state in the country and make him argue there, because of course he would really be helpful for me, for the cause of the client. But what about clients who actually need justice and need to knock at the doors of the courts, which are actually shut because they don't have digitization available? So you need to look at that aspect as well. So in that sense, the court functioning is, I'm afraid to say, not up to speed. We need to find solutions to get, because I know some places where the parties are not ready to argue their final matters because they know they will not be able to support the best cause of their client. They will not be able to assist the senior advocate to the best of their abilities, which they would have been able to do in case of physical presence. Similarly, with arbitration, of course, it's the way to go forward. But there are doubts raised internationally as well as in the domestic arbitration circles about how to conduct cross-examinations. How much do you trust a witness not being tutored by a lawyer when you don't have access to his phone, to his other electronic modes, whether he's being given those tips via WhatsApp by his lawyer or not? I know these are unethical means, but you cannot ignore. So there has to be a way found out to remove these hurdles or overcome these hurdles so that we can provide effective justice. That's my 2 bit.
Great. That's fantastic. That's a good ringside perspective that you gave, Mr. Sobti. So before we get into the second round, where I'm sorry, we'll only get 1 minute per speaker because we've really extended, gone beyond our time limits. But before we do the second round, quick 2 questions that we have received. And I'll take the first question by a senior citizen, because seniors first. The senior citizen wants to ask, the experts here, he has this property which he has given out on rent, and the tenant is not paying the rent for whatever reason, though the capability of paying rent is not the issue. He wants to maintain a good relationship, but he's not paying, and he's not even possibly evicting the property, So, but in his deed, he has this thing mentioned that within 30 days or whatever, X number of days of not paying rent, the tenant would be deemed as a trespasser. So this particular clause in the rent deed, can this help him or her get the criminal law on his side, or some urgent civil orders if they can be passed? That's how, what can this line help him expedite, get his property back, in short?
The short answer is no.
That was really short and to the point.
You can write anything, but even cardinal will be yours if that doesn't happen. It has to go through the process of law, whether it is civil or criminal.
Actually, he wanted to ask that.
The short answer is no, and the long answer is also no. He has to go through the grind.
So if he files a police complaint of trespass because that person now, as per the lease date, has been declared as a trespasser, can that help in putting pressure, or can that help in some aspect?
If he knows somebody in the police station, the answer is yes, otherwise no.
So Anuj, let me also intervene in this because we have been advising a few clients on both sides, as a landlord as well as tenant. So the response is definitely no on an immediate basis. This does not call for a criminal complaint to be filed for trespassing. But yes, he has his ways of going to the civil court for seeking eviction of the tenant in case of not paying the dues, and he can ask for deposit of the rent amount before the court. That is a solution which is available as an interim measure. The amount gets deposited in court, and then the landlord has the ability to request the court to release that amount to the landlord. That would be the best way of going forward in these kind of circumstances.
So that would take minimum half a year, if I'm not wrong.
So immediate relief that he will get is that he will start getting the money when the court directs the tenant to start depositing the money. So that money will start getting deposited before the court and can be released to him. So that is something which he can get as an immediate relief. Going to the police is not really a solution to this kind of a problem.
Police as it is overburdened right now, so don't disturb the police.
I mean, even if you go to the police, what is the kind of direction that you're seeking from the police? I mean, what kind of a criminality are you attributing? Trespassing. So trespassing is something which has to be established. Police is not an adjudicatory authority to decide on whether there is a trespass which has happened or not. The police does not have the ability to interpret a contract either ways. That is something which a court can only do.
Absolutely right. It is only creative writing. It only adds to the conclusion. Nothing else.
Okay. So the possible solution to it is that the landlord can approach the court for some emergency orders to be passed, for the rent to be paid, and to and of course he might get the rent fast enough. But yes, eviction will be as per the proceedings. So that's possibly the solution we're looking at. All right, fair enough. So next question is
it's 6 o'clock.
from Miss Anjali, that will revealing the name of arbitrators during the challenge proceeding instill a sense of integrity? She's also posted in the chat here.
Could you please repeat the question?
Yes, it's there in the chat as well, Vineet bhai. It says that will revealing the names of arbitrators during the challenge proceedings instill a sense of integrity?
No, absolutely not.
No, it is written. You challenge an order. It is written on the face of the order the name. So this question is not correct.
When you bring in a challenge to the court, you have to diverge the name of the arbitrator as to whom you are challenging and what basis are you challenging. So it anyways is there in the court records, the counsel.
And secondly, the Arbitration Act has been recently amended in 2019, read with 2015 amendment, where the arbitrator has to give the declaration about integrity. So that itself is on record, and whenever any adjudicating authority or the appellate authority will reach to the matter, definitely he will know who has decided the case. Yeah.
Fair enough. Fair enough. All right.
Yeah.
So, as we wait for any more questions to come, we can start with the second round. But friends, we'll just have to speak 1 minute per participant, because that's the only time we have left now. So we again begin with Mr. Jain. Mr. Jain, some remarks from your end after listening to all the speakers today.
No, I think the message is very clear that things will many disputes will come, many differences will come. And the question is, what would be the most effective way in which it can be addressed? There's no one glove fit all. But I think a very important point that Vineet made, which I wanted to touch on in round 2, is that the legal genesis of all this is really from the multiple circulars and directives issued by the government. So maybe the starting point is pandemic as it happened, but the legal effect and consequence emanates from the various directives which have been given, which affects different industries differently. And perhaps there one route that a lot of people are considering is considered change in law, because as opposed to force majeure, change in law also gives you some kind of compensation to offset the adverse effect there is. And second, on a lighter note to end, that one thing we all, at least for all of us men, we were looking at haircuts. We were deprived of haircuts in this period. So number of contractual obligations will also see haircuts of different types, as the IBC had done. So it's perhaps haircut time and balancing time.
Great. Fantastic. And Mr. Jain, talking about haircuts and balancing, something for the MSMEs, as guidance or a philosophy, what they can abide by during these challenging times?
See, MSMEs anyway have the advantage of a special act. So if there are obligations on vendors which are not fulfilled, it has higher rates of interest, and there's a special act and a special machinery, so it comes with it. But as I always said, and that goes back to the elder respected senior citizen who asked a question, that's where the equity factor comes in. If a senior citizen goes and says, look, this is my only source of income and the man is not paying rent and he's working and earning, the equity or the sympathy factor comes in. Likewise, if you have a dominant player versus an MSME, the wind of the court will always be towards that person to balance the imbalance which exists in their contractual relationship. So these are aspects which will really happen depending on issue to issue, party to party, court to court, arbitral tribunal to tribunal, arbitral institutions. So it's difficult to give across the board solution.
Fair enough, Mr. Jain. Totally agree with you on this. So, Mr. Lamba, last few remarks from your end. In fact, your voice is better without the headphones on.
Okay. Okay. So what I want to actually say is that the time has come when we must put more money into technology. The courts must not find they've done much, but they should not find disputes running courts. If your offices can run, if everything else can run, courts can also run. With digitalization, the cost of digitalization would be less than the parking which is built in the Supreme Court and the High Court at Delhi. It costs almost nothing to digitalize everything. So therefore, there are some matters. So it is more used as an excuse. I have attended a call, a court hearing on WhatsApp call. So therefore, if there is a will, and it depends upon if it can happen in Haldwani in a small court, it can happen everywhere also. So a lot of things can happen. Not only Arnab Goswami, others can also be heard. There must have been. I agree that there were emergent and necessary reasons for that. I do not doubt that. But the question with respect to MHA orders and the migrant labor which was taken, and the Supreme Court would not have had a solution to that. Had it had the solution, it would have taken in the middle of the night. So these were the solutions. Are more than learning must happen, and I think as one of the articles which I had read of Justice Shah, which says that court should become a service rather than a place. So place meaning thereby that anybody can be. Today we were talking about. I was also looking at it that if in Noida I get an order for or against me, the appeal goes to Allahabad. Allahabad is further than going to Lahore. But with digitalization, sitting from anywhere, it will make no difference. Gopal Jain can argue from here to London, and Harish Salve from London can argue in India. So therefore, even if the parking lot, the money which has been spent by the Delhi High Court or the Supreme Court is spent on digitalization, this entire argument will go and justice will become a service. So that's the learning that we need to learn. This may not be the first pandemic, and this will not be the last. So therefore, it is time has come that we must get, and Neeti should provide services from anywhere. If she can attend the conference and do everything what she could do from Delhi, and I am sure those offices and fancy buildings will not be required insofar as those parts are concerned. And the entire process needs to be understood that today justice is high courts and supreme courts are not places, but they are service. And once this is understood, I think 90% of the problem will get solved. There is nothing, absolutely nothing, which can't be done online, which can be, and the bogey of witnesses and all, and WhatsApp messages can be called out for a very simple reason. You can have special rooms where people can sit under surveillance or something of that nature. And please do not forget, the witness is not an accused. There's a distinction between a witness and an accused. And in these arguments, most of the people who have been arguing have just forgotten the difference between a witness and an accused. Don't treat witnesses like accused. Make a special room in every city, maybe at a 4 kilometers or some, at a distance, where people can come and give evidences, rather than stopping the entire process and saying, "Ye to chutti ho gayi." So we will have to, difficult times will require uh, fresh solutions. And I think the solutions are there. We must only recognize that we need to ought to do it. And if we want to, we shall. There is nothing which is going to stop us. So I see a big change which needs to come in mindsets. Absolutely. And once that mindset changes comes, I think when the 6 of us can talk on this forum and 100 of them can listen, this is all what is required to functioning of a court in the High Court. I can understand where cross-examinations are required. What happened to those matters where the arguments are over, and for the last 6 months, the judgments have been reserved and the judgments have not come. So something ought to be done. We all need to be reasonable, fair, equitable, just, as Gopal said, and we need to find solutions.
Absolutely. Couldn't agree more with you on this, Mr. Lamba. And as you rightly mentioned, it won't be just hundreds. In fact, once this video gets posted on our social media handles and WAF TV, I'm easily expecting minimum 50K to 100K views to this video because of the value that it holds. And also, it's a pure question which I think should be possibly taken suo moto by Supreme Court or High Court, at the dilemma between the court parking extension vis-a-vis digitization, and just the way we have software as a service, we can have justice as a service as well. So with that, coming to Ms. Bharti. Ms. Bharti, your closing remarks.
Yeah, thank you, Anuj. So if we look at this situation, I think it has posed certain very complex and multifaceted challenges for all of us, and therefore including the justice delivery systems across the world. So if we look at the history, it teaches us that in times of disasters and economic disruptions such as the present ones which have been triggered by COVID, the legal disputes have also increased significantly, whether be it the employment disputes or the breach of contracts, bankruptcy, insurance claims, or family disputes, or supply chain disruptions, etc., that I've been talking about. So, in the light of the impending tsunami of legal disputes that are likely to arise, I think the lawyers as well as the judicial institutions will require a tremendous support, both technology and otherwise, to not get overwhelmed by it and be able to deal with it in a more positive manner. And I see there to be a future for bright for lawyers, especially in litigation, so that they are able to litigate wherever they are stationed. And as Manishji mentioned, whether it is Mr. Gopal Jain sitting and arguing a matter in Mumbai High Court or at Guwahati High Court, will not make any difference. And imagine the kind of time that we are saving in commuting and are able to give effective attention to that matter. In fact, in today's time, I'm attending almost about 2 to 3 matters in a week. Sitting here in Delhi, I'm able to attend a hearing in Mumbai High Court or in Chindwara District Court or in Guwahati High Court or in an NCLT at Mumbai and Delhi. I mean, these are opportunities which have been thrown to us because of the present situation, and it is only helping us gear up. The other aspect I would like to touch upon is that if you look at countries like USA or China or Brazil, or even some European nations, that they have already adopted to ODR mechanism, and they have started constituting their separate platforms to resolve disputes arising out of these e-commerce transactions. So millions of disputes have already been dealt with successfully without even filing a single suit in a traditional court of law. So if in India also, because ODR is still in infancy, ADR we have been promoting for many years now, but ODR still is in its infancy stage. But it is a matter of time before ODR is also adopted at a large scale in India. And if you look at the statistics of the number of cases that are pending in different high courts, I think it will really help us resolve the backlogs from the tribunals and the courts. And we need the focus that we need to do is to give ODR platforms a more focus. And ODR mechanisms they are simple, they are effective, and they have the potential to come into mainstream dispute resolution system as well. And the acceptance of it will not be called into question. So I see that in the near future, ODR will not only serve as a platform for quick disposal of cases, but it will also be an area of employment for thousands of lawyers and arbitrators.
So for the convenience of our viewers, I just mentioned ODR is the online
dispute resolution. Yes.
And ADR, of course, is alternate dispute.
Dispute resolution.
ADR marries ODR and a new species is born.
Yeah, absolutely. Something like that is likely to happen very soon. And I think these are the times where probably is giving us the right platform to be able to create that kind of mechanism.
Inevitable. Great. Thank you so much, Ms. Bharti. So Vineet bhai, your closing remarks. We just have 3 minutes to go and we have 3 more speakers for their closing remarks. Yes, Vineet bhai.
Okay. I will take only 1 minute. The important point in the digital era we missed, and which is the part of the query also, the cyber fraud and the phishing attempts. So definitely we are exposed ourselves to the digital world. So the care or the key message is when you are working in an organization or something. So first, you are just not to have to invest in your IT system, also have to make good investment in the protection of your IT system. 2, create very well awareness in the system where any such attempt can be defrayed or defrauded. 3rd, important point, whatever the softwares, whatever you are using, because now we are using multiple software. So how to use this, get the knowledge is very important. So basically in this era where we are going more and more digital, so technically we are exposing ourselves, our privacy, exposing to the world, and we have to be little more sensitive on the perspective where a third party can encroach our privacy and third party can make an attempt for the cyber frauds or phishing. So we have to create our complete system sensitivity among the organization or the players where this can be stopped. That's all from us.
Great, fantastic. Okay, Ms. Sachdeva, all yours. Your closing remarks, please.
Thank you, Anuj. As an institution, I have to be efficient and keep to the time, so I'll take about 30 seconds. I think it's time to rethink, reinvent. And as lawyers, we need to up our game. That's the only thing. We may want to run away from technology. We may want to run away from experts. We can't do it anymore. This time, this era will not let us do that. So the sooner that the lawyers take up this technology, learn this, implement it, I think the sooner we can reinvent ourselves and rethink ourselves.
Beautiful. Thank you so much for that, Mr. Deva. Okay, so Mr. Sobti, Any last word of yours on the dispute resolution for our members?
I'll take a cue from Neeti, and I will also take just 30 seconds. In fact, I completely agree with all the panelists that the future is technology. That's how we have to adapt it. We have to work with it. We have to better it. And in fact, there are so many advantages. So there is actually nothing which we should apprehend or worry about in the future from technology. In fact, I have been part of court hearings where the court mannerisms were adopted to the T. In fact, I was surprised that they were better than court hearings, because the other one, if they were being rude, if they wanted to have the last word, which many of us want to as litigators, they were put on mute, which was very easy for the judge to do. So it's a very simple solution that technology offers you to put people in line. So we should all welcome it. That's my last word.
That's fantastic. So mute, unmute helps, whether it's a preschool class or the courtroom. It always helps.
I wish I had that button.
Okay. Okay, one last question just come in. It's a very relevant question because we didn't touch this topic. Cyber attacks, as we had discussed that, India is the second most cyber attack country in the entire world. So the person wants to ask, if there is a cyber attack, what should be the process? What should they do, once they are cyber attacked? What are their rights, duties, in case of a cyber attack? Quickly, if you can just answer any one of us, please feel free.
Just to my knowledge, sorry.
Please go ahead, sir.
I will take only, sir, 15 seconds. First of all, damage has been done. So definitely you can only collect the evidences or information. But here the problem is, where is your enemy? You do not know. The important point is learning from that and move forward, secure your mechanisms. Second, if you get any concrete basis, you can approach to the cybercrime office and to redress your concern. And in my experience, it is less effective, but yes, it's way of life. Mr. Sobti ji.
So I was about to say the same thing, that in these kind of cases, prevention is better than cure. And once you're hit by such offense or such kind of a loss or damage, the take that you get from it is that basically you invest in your systems. As all of us are working from home, we are exposing ourselves to such kind of cyber crimes. The government has been very active. They've been coming out with advisories, letting people know that in the wake of COVID, a lot of people are trying to make this kind of money, and that's why we need to really be cautious. That's the important word. There are procedures in place. If there is a banking fraud, there are bank ombudsman, there are banking internal procedures which you can read online. There are available mechanisms which you can follow and register your complaints.
Great. And also the user wants to ask, where can they report? Like, of course, every police department in every city or state has a cyber cell department. I believe there are national cyber cells departments too. So how should the complaint be done? Which should be the first go-to department or cell for complaint? So,
in fact, if you go to any police station, it is their obligation actually to direct you and transfer your complaint to the requisite cyber cell. So it is not the person who has to do anything. Legally, it is the investigation authority, it is the police who has to actually ensure that the complaint is sent to the right person or the right cybercrime so that they can proceed ahead with the complaint.
So without the IO understanding, if a complainant goes to the police station, meets the IO on duty and says that my website's SSL8 encryption got infected, so that guy will say, "Ye ke ho gaya bhai." So how do you deal with such issues? How does a person explain? How does it get reported? Captured, transferred? So it might be a pretty much of a challenge.
Yeah, unfortunately, Anuj, we give them way less credit than they actually deserve. But honestly, if it is a situation like that where there are technical terms involved, where you need to explain the process, the best way is actually to put it on a piece of paper. In fact, now there are online grievance redressal sites also available. But the best way is to put it on a paper and inform the IO that they have to basically transfer it or put it to the requisite cyber cell, and they will take it on from there.
Great. Fantastic. I think this last question took extra 3 minutes. Otherwise, I think we were bang on time. So thank you so very much, dear speakers. Thank you so very much for making our day. And I'm sure our members will really love it when they see the video later, and also now who are there for the live discussion. And we'd also like to thank our team member, Jerry Sir, for helping us organize a beautiful discussion coordinate. Thank you so very much, Jerry Sir. Thank you so much. And thank you very much, fellow speakers. Have a great day. Stay safe. And see you soon in the real world post-COVID. Thank you so much. Thank you. Thank you.
Thank you. Thank you to everybody. Thank you.
Thank you, everybody. Thank you so much.
Yeah.